Good morning, everybody. I would like to extend a warm welcome to everybody here to the premises of the Permanent Court of Arbitration in the Peace Palace in The Hague for this hearing in the conciliation proceedings between the government of the Democratic Republic of Timor-Leste and the government of the Commonwealth of Australia, pursuant to Article 298 and Annex 5 of the United Nations Convention on the Law of the Sea, conducted under the auspices of the PCA as PCA case number 2016/10. As we agreed last time and decided by the Commission following the procedural meeting we had in July, this opening session of this hearing is being broadcast live on the internet as we speak. The transcript and the video will also be made available on the PCA's website following the conclusion of this session. And I would offer a quick reminder, as I did last time, for everyone to be sure to use the microphones when speaking to ensure that we get you on the webcast and we record all the remarks that you make. I see a lot of familiar faces, but also new faces from the procedural meeting of last month in this room. Delegations is a little bit larger this time around, and I see some additional people. So therefore, it would be useful, I think, to have a round of introductions before we go ahead. For the Commission, on my right, I have Professor Rüdiger Wolfram, and I have Judge Abdul Koroma. On my left, we have Professor Donald McRae and Dr. Rosalie Balkin. And at the ends of the table, I have able help. We have our registrar, Mr. Garth Schofield, to my right from the PCA, and Mr. Martin Doe, also from the PCA, on my left. And finally, as you will know, my name is Peter Taksøe Jensen, and I have the honor to chair this Conciliation Commission. May I now ask Timor-Leste to introduce the members of its delegation, please.
Sinan Guzman, member of my government and chief negotiator on the maritime boundary.
Vaughan Lowe, Counsel for Timor-Leste.
Michael Wood, Counsel for Timor-Leste.
Elizabeth Exposter, CEO of the Maritime Boundary Office and Deputy Agent.
Hermenegildo Pereira, also mostly known as Gil Pereira, the agent for Timor-Leste and Minister of State and of the President's Council of Ministers of Timorese government.
Stephen Webb, a legal advisor, partner, DLA Piper.
Janet Legrand, partner, legal advisor, DLA Piper.
Thank you very much. And Australia, can I ask you to introduce the members of your delegation, please?
Thank you, Chairman. My name is John Reid. I appear as agent for Australia in these proceedings again. Mr. Chair, Australia's opening statement this morning will be delivered by Mr. Gary Quinlan, the Deputy Secretary for the Department of Foreign Affairs in Australia, and Mr. Justin Gleeson, SC, Solicitor General of Australia. They're supported by Counsel Sir Daniel Bethlehem, KCMG QC, Mr. Bill Campbell QC, and Professor Chester Brown. Also appearing on the delegation is His Excellency Brett Mason, Australia's Ambassador to the Netherlands, and Ms. Katrina Cooper, my co-agent from the Department of Foreign Affairs and Trade. We are supported by, from the Attorney General's Department, Ms. Amelia Tellick, Mr. Benjamin Huntley, Ms. Anna Rangot, and from the Department of Foreign Affairs and Trade, Mr. Justin Wyatt, Mr. Todd Quinn, Ms. Angela Robinson, Ms. Indra McCormack, and Ms. Christina Hay-Nguyen, and from Geoscience Australia by Mr. Mark Alcock.
Thank you very much for that. I welcome all of you again. I wish to recall, as I did at the opening of the procedural meeting, that this is a conciliation rather than an adversarial process, and therefore we have arranged the room in a slightly more informal manner, and we hope that we can continue the very collegial atmosphere that prevailed during our procedural meeting. I note that the purpose of this public opening session is to give each side an opportunity to put forward the background and the dispute between the parties and their opening positions, so to say, from which we would hope to move forward towards a compromise and agreed settlement over the course of the conciliation. If they wish so, the parties may also address the question of the Commission's competence during the opening session. That question will also be addressed in detail during the remainder of the hearing of this week, following the conclusion of this opening session. Just before we begin, I wish to take a moment to go over the schedule. Each side will have 90 minutes for its opening presentation. Timor-Leste will start and have until approximately 11:15. Then we'll have a 15-minute break and continue with the Australia presentation until about 1 o'clock, before concluding the opening portion of the hearing and breaking for lunch. That will end the public portion of this hearing. For the remainder of the hearing, I note that we adjusted the schedule a bit last week at the request of Timor-Leste in order to fit everything we have to get done by the end of the day of Wednesday and leave Thursday for the Commission to meet and deliberate on its own. I note that the Commission remains flexible and we would stay a bit longer today, start earlier tomorrow, or adjust our breaks if that would help keep us within a reasonable end time tomorrow. Is there any other preliminary matters that we need to deal with? Then I would like to hear from the parties. That does not seem to be the case. Then I think I'll just give the floor to Timor-Leste for its opening presentation. You have the floor.
Thank you.
Mr. Chairman, members of the Commission, it is a great honour to appear before you as Deputy Agent on behalf of my country, the Democratic Republic of Timor-Leste. Timor-Leste is honoured to take part in this very first compulsory conciliation under the United Nations Convention of the Law of the Sea. We are also very appreciative of the Commission and the process led by it. Timor-Leste's statehood is a story of national perseverance, resolve, and hope. The people of Timor-Leste have paid an extremely high price for our independence, finally achieved 14 years ago. Despite the brutal occupation and fighting we endured, we did not emerge vengeful or vindictive. Throughout our struggle, our leaders preached tolerance and respect towards others. And though we do not forget our painful and difficult past, we are a resilient people that look forward first and foremost. After our independence, the Timorese people opted for reconciliation and building a new and peaceful relationship with our former occupiers. Now, times have changed, and the form of Timor-Leste's struggle has changed. With the majority of our population under the age of 25, our hope for nation building lies in the future. And it is up to the representatives of Timor-Leste to do their utmost to secure a better future for our young generation and their children. It is a national priority to secure our sovereign rights over our surrounding seas and the resources that lie therein, which hold the promise of a transformational development for our country. The future for the next generations would look very different without access to our seas. This is what brings us here today. Timor-Leste has initiated these proceedings to resolve our maritime dispute with our neighbour Australia in an amicable and collaborative way. We are here to pursue our rights for the sake of our people and take on the responsibilities of statehood like any other nation would. Timor-Leste may be young, but we are not naive. We will not shy away from claiming what is rightfully ours, and we will persist until this is finally achieved. We have faith that this Commission can assist us to settle our differences with Australia in a just and fair manner, and we look forward to working with the Commission and Australia to bring our maritime dispute to its conclusion for our future generations. Mr. Chairman, members of the Commission, in today's opening session, Timor-Leste will present to the Commission its overall position on the maritime dispute with Australia. We will provide you with the background and facts relevant to the dispute and outline Timor-Leste's position on its permanent maritime boundaries in the Timor Sea under international law. Mr. Chairman, members of the Commission, let me briefly introduce the members of the Timorese delegation to these proceedings. Our presentation will be opened by our founding father of our nation, the leader of the Timorese resistance, the first elected president of the Republic, the former Prime Minister, and now Timor-Leste's chief negotiator, His Excellency Minister Karala Xanana Guzmão. His Excellency will be followed by Professor Vaughan Lowe, QC, who will provide the relevant background for these proceedings, and in particular, the factual context that has given rise to the dispute between the parties. Then, Sir Michael Wood will present on Timor-Leste's maritime boundary under international law in the Timor Sea. Finally, Timor-Leste's agent, the Minister of State and of the Presidency of the Council of Ministers, Minister Ju Pereira, will make our closing remarks for this session. Mr. Chairman, I ask you to invite Minister Guzmão to address the Commission. Thank you.
Mr. Chairman, members of the Commission, I would like to thank you for the opportunity to appear before you on behalf of the government and the people of Timor-Leste. We greatly appreciate your commitment to assist in settling the long-running dispute between Timor-Leste and Australia concerning the maritime boundary in the Timor Sea. Mr. Chairman, the independence of the Democratic Republic of Timor-Leste was restored on 20 May 2002. Timor-Leste became the 191st member of the United Nations that September, but our story goes back long before that. Legend has it that the Timorese are the grandchildren of the crocodile. The body of our spirit ancestor became the land of Timor-Leste, his lumpy back forming the mountains and valleys that our people have been living on for hundreds of years. The surrounding waters were the habitat of our grandfather crocodile and have sustained us. They remain integral to our livelihood, culture and way of life. The Timorese people governed themselves before we were colonized by Portugal in the 1500s. After the Dutch colonized Indonesia, the island of Timor was divided in two, with the east administered by Portugal. During the Second World War, despite Portugal's neutrality, Australian soldiers arrived in what was then Portuguese Timor. Close bonds of friendship were formed between Timorese and Australian soldiers, a legacy of solidarity that both countries hold dear, with Australian veterans continuing to support our cause. The colonial era came to an end on 20 November 1975, when Fretilin declared the independence of Timor-Leste. 9 days later, Indonesia invaded our country. Over the next 24 years, our people endured the brutal occupation under the military dictatorship of the Indonesian regime. A resilient few mounted a guerrilla campaign in the hills and valleys of our country to free our people from oppression. But the odds and the strong Western powers were against us. Australia twice closed down our only radio connection in Darwin. cut off from the outside world. Little did we know that Australia gave formal recognition in 1979 to Indonesia's illegal annexation of our country, in defiance of numerous UN resolutions condemning the invasion and affirming the right of the Timorese to self-determination. Australia, however, went a step further. In 1989, it entered into an unlawful treaty with Indonesia to carve up the resources in the Timor Sea with total disregard for our sovereignty, which at that very time we are fighting and dying for. The image of the Australian and Indonesian foreign ministers flying over the Timor Sea while drinking champagne to celebrate the signing of the Timor Gap Treaty filled us with much sadness. But it motivated us to continue our struggle. With the sacrifices made by our people, our determination strengthened year after year until our fight came to an end with the fall of the Indonesian regime. On 30 August 1999, our people voted overwhelmingly for independence in a UN-sponsored referendum, which was held precisely 17 years ago tomorrow. This led to violence by militias and scorched earth operation. Our country was burned to the ground. Overall, the period of Indonesian occupation and its immediate aftermath led to more than 200,000 deaths, close to 1/3 of our population. Members of the Commission, rising above our troubled past, we have reconciled with Indonesia, which has also been freed from the grip of dictatorship and is now, like Timor-Leste, a democracy. Today, our nations have become a global model of reconciliation and friendship, and we have begun discussions to delimit our maritime boundaries. Timor-Leste has much to be proud of. We have consolidated a democracy with open market and the rule of law. Our petroleum fund handles every dollar of our resources revenue with transparency and accountability. We have built the foundations of a successful state, secured peace and stability, and have a 20-year strategic development plan for our future. However, as a consequence of centuries of colonization and decades of occupation, we remain one of the least developed countries. Our people have limited access to clean water and face some of the worst malnutrition rates in the world. We did not meet even one of the 8 Millennium Development Goals. Timor-Leste has yet to be completely freed from its past. While we are no longer oppressed, our sovereignty remains challenged. During the negotiations under the UN Transitional Administration, we raised many times the need to discuss the maritime boundary issue, but Australia showed no interest. Instead, 2 months before the restoration of our independence, in March 2002, Australia withdrew from the binding dispute resolution mechanism under UNCLOS under the International Court of Justice, specifically on maritime boundaries. On the very day of the restoration of our independence, we were faced with the indignity of having to sign the Timor Sea Treaty, the near mirror image of the 1989 Timor Gap Treaty. Mr. Chairman, members of the Commission, you must understand that at the time, Timor had nothing. Our land was scorched, our people killed by hundreds of thousands. More than 70% of our infrastructure, including schools and hospitals, were burned. We had no money, forcing us to beg every 6 months to the international community for funds just to sustain the UN Transitional Administration and some basic services. This situation made us vulnerable to duress and exploitation. Yes, we had advice from the UN and elsewhere, but given the history leading to the restoration of independence, we were entirely in their hands and in no position to take informed decisions of our own. Thereafter, we wanted to negotiate a permanent maritime boundary with Australia based on international law, a median line. Australia, however, refused to enter into serious discussions on a maritime boundary. Inexperienced in negotiations, ignorant of our rights and desperate for revenue to rebuild our country from ruins, we succumbed to Australia's pressure and signed the CMETS Treaty to facilitate the development of the Great Sunrise Field. We were not aware at the time that under the cover of an Australian aid program renovating Timor-Leste government offices, Australia installed listening devices to spy on the Timorese officials negotiating CMETS to maximize their advantage and commercial interest. When this came to light, we were shocked and appalled. I myself tried my best to persuade successive Australian governments to sit down as friends to discuss the problem and to work towards a maritime boundary agreement, but they still refused. I should mention that the Australian opposition has recently committed to negotiate a maritime boundary with Timor-Leste and review Australia's jurisdictional carve-out. Yet, even as recently as this month, the Australian government has declined an invitation from Timor-Leste to negotiate. Australia's refusal to negotiate maritime boundaries with us is difficult to explain. Australian maritime areas are over 100 times greater than ours. Australia has the third largest maritime area in the world, with enormous resources and wealth. The area in question in the current dispute represents just 1.8% of Australia's maritime area. Australia has settled these maritime boundaries with all its neighbours, all but Timor-Leste. Even today, Timor-Leste is willing at any time to submit our boundary dispute to an international tribunal or court, but with its withdrawals, Australia turns its backs on the law. Members of the Commission, that is how we find ourselves in front of you today. We have not come to the Hague to ask for favors or special treatment. We have come to seek our rights under international law. Even someone such as myself, educated in jungles of Timor and in prison, understands the basic fairness and common sense, let alone international law, dictates that the maritime boundary between two opposite countries should stand halfway between them. The story of our long struggle for sovereign rights over our seas is told in Timor-Leste's policy paper on maritime boundaries, which, I'm pleased to note, the Prime Minister of Timor-Leste is launching today in Dili. This paper conveys the importance of maritime boundaries to our people and to the future of our nation. Copies are available. Mr. Chairman, members of the Commission, the achievement of maritime boundaries in accordance with international law is a matter of national sovereignty and the sustainability of our country. It is Timor-Leste's top national priority. So many Timorese people have fought and died for our sovereignty. Our brothers and sisters, our family, and our friends. It saddens us still to think of those times and the terrible sacrifices and choices that no person should ever have to make. Securing our maritime rights will be the end of Timor-Leste's long struggle for sovereignty. We will then finally be able to enjoy in peace and dignity the rich and beautiful seas that are rightfully ours. just as we fought so hard and suffered so much for our independence, we will not rest until we have our sovereign rights over both land and sea. Mr. Chairman, members of the Commission, Timor-Leste looks to your Commission to assist the parties to find a path towards agreement. We know that it will not be easy, but we approach the process constructively and in good faith. We have confidence that our friends across the table and the seas will respect this process and cooperate with goodwill. Mr. Chairman, members of the Commission, I thank you very much. I now ask you to invite Professor Van Loo, Council for Timor-Leste, to address the Commission. Thank you.
Thank you, Chairman. Thank you, members of the Commission. As you've heard from our chief negotiator, Timor-Leste is a small coastal country in Southeast Asia. To the north, west and east lies the Indonesian archipelago, and to the south lies Australia, about 300 nautical miles across the Timor Sea. The island of Timor was ruled for centuries by two ancient kingdoms, one in the east and one in the west. Portuguese missionaries arrived on the island of Timor in 1515, and Portugal later claimed the current territory of Timor-Leste and called it Portuguese Timor. The Dutch claimed the territory of West Timor, which is now part of Indonesia. During that colonial period, no maritime boundaries had been fixed for Timor-Leste. By the early 1970s, Australia was aware that both Portuguese Timor and Indonesia disputed Australia's right to issue exploration permits closer to Timor than to Australia. Portugal, which then still governed Timor-Leste, approached Australia with requests to commence maritime boundary negotiations, but Australia rebuffed those approaches. Instead, in 1971, Australia began negotiations on seabed boundaries with Indonesia to establish jurisdiction over the seabed and its resources. Portugal was excluded from the negotiations. In May 1971, Australia and Indonesia signed a treaty creating a partial seabed boundary that covered the Arafura Sea and the eastern part of the Timor Sea, based on equidistance principles. In October 1972, they signed a second treaty establishing permanent seabed boundaries in the Timor Sea, and that came into force on the 8th of November 1973. As Portugal did not participate in those negotiations, the seabed boundary established by that agreement could not address the maritime boundary between Timor-Leste and Australia, thereby creating what came to be known as the Timor Gap. And the size of the gap was determined by Australia and Indonesia, without Portugal's input. In June 1974, less than 2 years after the signing of the second seabed treaty between Australia and Indonesia, the Australian company Woodside drilled in an area north of the median line and just south of the 1972 boundary line, confirming the discovery of oil and gas reserves in the Greater Sunrise Field. By 1974, Portugal began the process of decolonisation. But in 1975, following internal strife, the Revolutionary Front for an Independent East Timor, Fretilin, won control of the territory of Timor-Leste. And on the 28th of November 1975, it declared the territory's independence. 9 days later, in December 1975, in a gross violation of international law for which it was repeatedly condemned in the United Nations, Indonesia invaded Timor-Leste using armed force and occupied the country. During the 24 years of occupation, Timorese freedom fighters ran a national resistance campaign. Close to 1/3 of the population were killed, disappeared, or died due to conflict-related hunger and illness during that occupation. And on the 14th of February 1979, Australia announced its de jure recognition of Indonesian sovereignty over Timor-Leste. Australia was the only state in the world that purported to recognize that flagrant violation of international law. And it did so in order to commence negotiations with Indonesia over the boundary in the Timor Gap. Indonesia and Australia officially began attempts to close the Timor Gap, and Australia hoped to draw a line connecting the endpoints of the existing seabed boundaries with Indonesia, points A16 and A17 on the maps. But Indonesia refused to agree and adopted Portugal's position, arguing for a median line boundary. As Australia and Indonesia could not agree on a maritime boundary, they instead negotiated over the sharing of resources in the Timor Sea. And while Timor-Leste remained under Indonesian military control and occupation, in contravention of numerous United Nations resolutions, Australia and Indonesia spent a decade negotiating together a joint arrangement to divide up the resources of Timor-Leste, illegally extracted from within a coffin-shaped area in the Timor Sea known as the Zone of Cooperation. This agreement, the 1989 Timor Gap Treaty, came into force on the 9th of February 1991. The boundaries of that zone left rich resources to Australia, north of the median line and just outside the western and eastern boundaries of the Zone of Cooperation, in areas to which Timor-Leste had and has an obvious claim. Less than 2 weeks later, Portugal instituted proceedings against Australia in the International Court of Justice. Australia objected that the court had no jurisdiction, saying that there was no dispute between Portugal and Australia, but only a dispute between Portugal and Indonesia. Well, the court rejected that Australian objection, but held that the case could not proceed in the absence of Indonesia as an indispensable party, and so that case ended. In 1994, the United Nations Convention on the Law of the Sea, signed in 1982, came into force, recognizing the rights of coastal states to an exclusive economic zone up to 200 nautical miles and a continental shelf of at least 200 nautical miles from its baselines. Australia ratified UNCLOS on the 5th of October 1994. The 1972 treaty between Australia and Indonesia had dealt only with the seabed boundary, not with sovereign rights over the water column and its resources. And in 1997, Australia and Indonesia negotiated a further boundary treaty, which delimited the exclusive economic zone, excluding seabed rights. And in stark contrast to the 1972 Australia-Indonesia seabed treaty, the 1997 exclusive economic zone treaty followed an equidistance line. And this resulted in the remarkable phenomenon of split jurisdiction. as a large area of the Timor Sea. Australia has, broadly speaking, rights over the seabed, and concurrently Indonesia has rights over the water column. The 1997 treaty was never ratified and is not in force, but a provision of CMATS stated that the split between seabed and water column jurisdiction would continue. All of this occurred while Timor-Leste was under military occupation by bilateral agreement between Australia and the occupying state. In late 1999, after its UN-sponsored independence referendum, Timor-Leste began the transition to statehood. And it is right to recall here the gratitude of the Timorese people for the courage and solidarity of the Australian troops who led the UN peacekeeping mission at that difficult time. The illegal 1989 Timor Gap Treaty between Australia and Indonesia ceased to have any effect when Indonesia formally relinquished control over the territory. And the United Nations Security Council gave responsibility for the administration of the territory until independence to the United Nations Transitional Administration in East Timor, UNTITE. In early 2000, Australia and UNTITE concluded an exchange of notes which allowed Australia and Timor-Leste to continue petroleum activities in the Timor Sea. And this was formalized in July 2001 in a memorandum of understanding in which Australia and the UN administration agreed that the Timor Sea arrangement would govern exploitation of the Joint Petroleum Development Area, the JPDA, which succeeded the Timor Gap Treaty's zone of cooperation, upon Timor-Leste's independence. 2 months before Timor-Leste formally regained its independence, Australia excluded maritime boundary disputes, both from its acceptance of the jurisdiction of the International Court of Justice and also from the binding dispute resolution bodies under UNCLOS, thus enabling Australia to refuse to allow any court to settle the boundary with Timor-Leste in accordance with international law. And then on the 20th of May 2002, Timor-Leste restored its independence. On the day of its independence, Timor-Leste signed the 2002 Timor Sea Treaty with Australia. The Timor Sea Treaty set up a provisional, temporary arrangement to govern the exploitation of oil and gas resources in the Joint Petroleum Development Area, JPDA, and the sharing of revenues, pending final delimitation of maritime boundaries consistent with international law. And fields such as Bayou Undan, within the JPDA, would be within Timor's seabed if the boundary were drawn along the median line used in the 1997 Australia-Indonesian EEZ Treaty. On the same day, Australia and Timor-Leste signed a memorandum of understanding concerning an international unitization agreement for the Greater Sunrise Field. The Greater Sunrise Field straddled the eastern lateral side boundary of the JPDA. So the parties had to agree how the field would be jointly exploited. Australia and Timor-Leste signed an agreement to unitize Greater Sunrise in early 2003, which provided that 79.9% of the field was deemed to belong to Australia, and 20.1% was deemed to fall within the JPDA. The Timor Sea Treaty was ratified by Timor-Leste on December 17, 2002, and entered into force on the 2nd of April 2003, but is stipulated to have effect from the date of signature on the 20th of May 2002. The unitization agreement did not come into force until the 23rd of February 2007. In April 2004, Timor-Leste and Australia commenced negotiations on a maritime boundary. Timor-Leste argued that the delimitation of the JPDA did not reflect international law, as the boundary should be the median line, and the lateral lines, the lateral boundaries of the JPDA, should lie further west and east. Australia offered billions of dollars in compensation for Greater Sunrise, but Timor-Leste declined. Australia then refused to negotiate a maritime boundary and was willing to consider only a provisional resource sharing arrangement in the Timor Sea. And those talks resulted in the conclusion of the 2006 Treaty on Certain Maritime Arrangements in the Timor Sea, CMAT, which established a new temporary resource sharing arrangement. It was intended as a provisional arrangement that would enable the opening up of the Greater Sunrise Field. CMAT amended the Timor Sea Treaty to allow Timor-Leste a greater proportion of revenue from Greater Sunrise. But it also contained a moratorium on, quote, asserting, pursuing or furthering its maritime boundary claim for the next 50 years. Well, that's a remarkably long time, long enough to reach beyond the end of the commercial life of the Greater Sunrise Field. And in effect, this provisional arrangement would be the only arrangement governing Greater Sunrise. It was also provided in CMATs that CMATs itself, and by extension the Timor Sea Treaty, could be terminated unilaterally by either state if a development plan for Greater Sunrise had not been approved within 6 years after the entry into force of CMATs. That deadline passed on the 24th of February 2013, and since that date, either state has been entitled to terminate CMATs. CMATs failed as a treaty. It did not lead to the development of Greater Sunrise, and it's outlived its usefulness. Exploitation has taken place elsewhere in the JPDA. The most lucrative field is Bayu-Undan, which was discovered in 1995 and was estimated to hold around 400 million barrels of condensate and 3.4 trillion cubic feet of gas. Condensate production commenced in 2004, and gas production commenced 2 years later. And a 500-kilometre subsea pipeline from Bayu-Undan to Darwin, Australia, was completed in 2006. The Bayu-Undan field is still actively producing. Other oil and gas fields, such as Khitan, were discovered later within the JPDA, but these fields have now mostly been exhausted. Well, as is evident from this summary, there has never been any agreement on permanent maritime boundaries between Timor-Leste and Australia. The Timor Sea Treaty and CMATs were expressly conceived as temporary provisional arrangements, pending agreement on permanent maritime boundaries and without prejudice to the location of those permanent boundaries. Several years after CMATS was agreed, Timor-Leste received information from a former Australian intelligence officer that Australia had secretly installed listening devices in the offices of the Timorese cabinet under cover of an Australian aid program, and had bugged discussions of the Timorese government team negotiating the CMATS treaty. On the basis of this flagrant violation of international law and Timorese sovereignty, and of the duty to negotiate treaties in good faith, Timor-Leste advised Australia that it considers CMATS to be null and void, and that the Timor Sea Treaty continues to operate unamended by CMATS. Australia rejected that view, and Timor-Leste commenced arbitration proceedings against Australia at the Permanent Court of Arbitration here in The Hague, under the Timor Sea Treaty, seeking a declaration that the Timor Sea Treaty has not been modified by CMATS. While those proceedings were underway, on the night before the opening of the first hearing at The Hague on the 3rd of December 2013, Australian security intelligence officers raided the offices of one of Timor-Leste's lawyers in Canberra and seized documents and data belonging to Timor-Leste. The documents contained internal legal advice for Timor. Despite Timor-Leste's requests, the Australian government refused to return these materials. Timor-Leste promptly commenced proceedings in the International Court, seeking, among other things, a declaration that the seizure and detention of those materials was unlawful. In March 2014, the ICJ ordered Australia to seal the seized documents and data and to keep them sealed until the court's final decision. And the court also directed, by 15 votes to 1, that, quote, Australia shall not interfere in any way in communications between Timor-Leste and its legal advisers in connection with the pending arbitration, with any future bilateral negotiations concerning maritime delimitation, or with any other related procedure between the two states. The one dissentient was the Australian-appointed ad hoc judge. Australia requested Timor-Leste to suspend the espionage arbitration and the ICJ case in order to allow for bilateral consultations. And Timor-Leste agreed to do so. As a gesture of goodwill, Timor-Leste subsequently terminated the ICJ case after Australia returned the documents that it had seized. Nonetheless, Australia refused to begin negotiations on permanent boundaries and insisted that it would engage only in consultations with Timor-Leste. During those consultations, Timor-Leste proposed various steps to facilitate agreement on permanent boundaries, including a consensual conciliation progress. Australia was unwilling to agree to any such steps, and while the differences between the parties were clarified and the contours of the dispute became clear at this time, the consultations failed to achieve progress. It was against this background that Timor-Leste decided that there is no course open to it in its efforts to persuade Australia to negotiate permanent maritime boundaries other than recourse to compulsory conciliation under the Law of the Sea Convention. And Timor-Leste accordingly initiated this conciliation process. It's also informed Australia of its firm policy that CMATs will go, and go soon. It may be declared void by the TST tribunal, or without prejudice to its position that CMATs is void as a consequence of Australia's unlawful spying on the Timorese negotiators, Timor-Leste will, if necessary, exercise its right to terminate it unilaterally. CMATs was set up as a temporary arrangement enabling the opening up of the Greater Sunrise Field. It failed in that aim, and it no longer has any purpose. Timor-Leste has made it very clear to Australia that it much prefers that the termination of CMATs, and with it the termination of the Timor Sea Treaty, should be a step taken jointly with Australia. That would ensure a smooth transition for the benefit of both states and also of the petroleum industry. Timor-Leste is acutely conscious of the fact that it is a very young nation, emerging from a period of great fragility. Its handling of the Timor Sea question will colour its reputation among other states and among foreign investors for many years. If notice of termination is given according to Article 12 of CMATs, there is only 3 months in which to establish transitional arrangements before CMATs ceases to have effect. And for this reason, Timor-Leste will not be bounced into precipitate action to terminate CMATs. It will first do all within its power to ensure that proper provision is made for an orderly transition to permanent maritime boundaries and a new legal regime. And for that, it needs the constructive engagement and cooperation of Australia and the expert assistance of this Commission. Timor-Leste has at present no permanent maritime boundary with Australia. It is the only neighbouring state with which Australia has no maritime boundary, as the slide on the screen shows. There will shortly be no provisional arrangements in place. And in these circumstances, Timor-Leste comes to the Commission to explain what it believes its entitlement under international law to be. We regret that Australia has raised jurisdictional objections to the work of the Conciliation Commission. We have no doubts concerning its competence, and we've already made our written response to Australia's arguments. That said, we fully accept that the wide competence of the Commission to consider, indeed that it's required to consider under the Law of the Sea Convention, Australia's points on the validity of CMATs and so on are part of its remit. Conciliators inevitably have to deal with the situations and sensibilities of disputing parties as they find them, case by case. With your permission, Sir, Sir Michael Wood will now continue with Timor's opening statement.
Mr. Chairman, members of the Commission, my task today is twofold. The main part of my statement will outline Timor-Leste's position on where its maritime boundaries in the Timor Sea lie under international law. Then I will briefly set out how Timor-Leste sees the Commission's role. We will, of course, go into these matters in more detail at subsequent stages of the proceedings. Timor-Leste and each of its neighbours, Australia and Indonesia, are parties to the United Nations Convention on the Law of the Sea, UNCLOS. it follows that the delimitation of the overlapping maritime entitlements of Timor-Leste and its neighbours is governed by the provisions of UNCLOS concerning the delimitation of the territorial sea, the exclusive economic zone, and the continental shelf, as applied in the case law of international courts and tribunals. Of particular relevance for these proceedings, for these conciliation proceedings, are Articles 74 and 83 of UNCLOS, which lay down the rule for the delimitation of the EEZ and continental shelf. As you know, they provide that the delimitation of the EEZ and continental shelf between states with opposite and adjacent coasts shall be effected by agreement on the basis of international law, as referred to in Article 38 of the Statute of the International Court of Justice, in order to achieve an equitable solution. UNCLOS goes on to provide that if no agreement can be reached within a reasonable period of time, the states concerned shall resort to the dispute settlement procedures provided for in Part 15 of UNCLOS. Mr. Chairman, members of the Commission, as you're very well aware, the international law on maritime delimitation has evolved significantly over the years. It has done so in parallel with the development of maritime entitlements that resulted from the negotiations at the Third United Nations Conference on the Law of the Sea. And it's important to bear in mind this evolution of the law when we consider developments in the Timor Sea. In the early 1970s, when Australia was negotiating with Indonesia, under the law of the sea as it then stood, it might have been possible to construct a legal argument for extending Australia's shelf beyond the median line, and even right up to the Timor Trough. But the law has changed. There is no such argument under the modern law of the sea, although Australia sometimes still seems to suggest otherwise. The story is well known, and I do not need to go into details. In essence, under the legal regime of the continental shelf, as it stood in the early 1970s, a central concept was natural prolongation. Arguments about geomorphology, the shape of the seabed, used to play an important role in negotiations and litigation at that time. States sought to argue that their continental shelves extended as far as a natural break in the seabed. But even at that time, state practice did not accept such arguments, as is clear, for example, from the 1966 agreement between Norway and the United Kingdom over the North Sea. Since those very early days, the international law of maritime delimitation has changed radically. The negotiations at the Third Law of the Sea Conference led to the acceptance of 200-mile exclusive economic zones and a minimum 200-mile continental shelf entitlement. The case law has taken these developments into account and established conclusively that within 200 miles of the coast, natural breaks and geomorphology now have no legal relevance. It is also now clear that in most circumstances, international law prescribes a three-stage methodology for achieving the equitable solution required by Articles 74 and 83. This three-stage approach has been developed in the case law of the International Court of Justice and of the Law of the Sea Tribunal in Hamburg, as well as in a number of distinguished arbitral tribunals. The three-stage methodology will be familiar to the members of the Commission, and I'm sure I don't need to go into details. I would simply recall that at the first stage, a provisional equidistance or median line is constructed. At the second stage, one looks to see if there are any relevant circumstances that might call for an adjustment of the provisional equidistance line in order to achieve an equitable solution. Such circumstances, for example, may be when a state is squeezed between another state or states and its maritime entitlements are cut off, or when the delimitation is between the mainland coast of one state and another state's small islands, which are to be given less weight in the delimitation process. And then at the last of the three stages, a disproportionality test is conducted to ensure that the effect of the line thus reached is such that the parties' respective shares of the relevant area are not grossly disproportionate to the ratio of their coastal lengths. So that, Mr. Chairman, is a very brief sketch of the law applicable to identifying Timor-Leste's maritime boundaries, and in particular its maritime boundaries with Australia. And with that in mind, I'll now sketch out the application of the law in the present case. Based on the relevant coasts of Timor-Leste and Australia, and after identifying the relevant base points in each case, the calculation of the provisional equidistance line at the first stage of the three-stage methodology is a straightforward geometrical exercise. The map on the screen shows the equidistance or median line with the construction lines connecting the base points on either side. The median line has been extended to the east and west without prejudice to the eventual delimitation with Indonesia. The second stage is to consider whether there are any relevant circumstances that might require the adjustment of the provisional equidistance or median line. In the present case, there would seem to be no such relevant circumstances as regards the line on the screen. However, Australia might take the position that at the first stage, base points should be located on Holothuria reefs, which are now being pointed out on the screen. You can see them just north of the Australian coast. Despite the fact that there are only a few very small rocks within those reefs above water at high tide. If one were to do this at the first stage, then it's clear that the reefs would then have to be discounted at the second stage as a relevant circumstance. I would, however, point out that because Australia has taken account of the Holothuria reefs in determining a median line, its very recent acreage release covers areas of overlapping claims and in fact encroaches on the area claimed by Timor-Leste. And you can see that with the slight sliver just above the median line on the screen. This acreage release, which was made on the 11th of August this year, the 11th of August 2016, just 18 days ago, stands in contrast to Article 10, Paragraph 3 of the Commission's Rules of Procedure, which provides that the parties shall refrain during the conciliation proceedings from any measure which might aggravate or widen the dispute. Mr. Chairman, members of the Commission, the third stage, the final stage of the three-stage methodology is the application of the disproportionality test, and in this case, the median line that we have thus constructed creates a division of the relevant area that does not create any disproportionality requiring a shifting of the median line. So, the result of applying the three-stage methodology required by international law, required by the case law, is to delimit the overlapping maritime entitlements of Timor-Leste and Australia in the Timor Sea in the way that you can see on the screen. That, we say, is the median line dictated by the provisions of UNCLOS, and it provides an equitable solution. Mr. Chairman, by way of background, and only by way of background, I shall now say a few words on how the methodology might apply to the lateral boundaries to the east and west, where Timor-Leste also shares a maritime boundary with Indonesia. Of course, we have to bear in mind that Indonesia is not a participant in the present conciliation, which concerns only the maritime boundary between Timor-Leste and Australia. As Minister Gusmão has explained, discussions on maritime boundaries are now underway with Indonesia. And nothing we say at this hearing is intended to affect in any way those negotiations. In the West, a provisional equidistance line would be drawn at the first stage from the land boundary terminus between Timor-Leste in the east and Indonesia in the west. At the second stage, there is, in Timor-Leste's view, a significant relevant circumstance. Timor-Leste's maritime entitlements are effectively cut off because of the concavity of its coast, squeezed between Indonesian entitlements from east and west. And due to this relevant circumstance, the equidistance line would be shifted to the west to provide an equitable solution. It should be noted that over the years, in this disputed area of overlapping claims, just west of the JPDA, Australia has developed and depleted 3 oil and gas fields, Laminaria, Corallina, and Buffalo. The location of these fields is shown on the screen. On a side note, I would comment that the acreage release of 11th August this year, which I've just mentioned, shows that Australia's habit of exploiting natural resources in disputed areas continues even while these proceedings are in train. Mr. Chairman, in the east of the Timor Sea, at the first stage, a provisional equidistance line would be drawn from a point between Timor-Leste's Yako Island and the small Indonesian islands to the east. At the second stage, the provisional equidistance line is to be adjusted to take account of relevant circumstances. In addition to the concavity of Timor-Leste's coast, the small and scattered Indonesian islands to the east of Timor-Leste, the Leti Islands, are also an important relevant circumstance. International judicial bodies have repeatedly found that islands such as these should be given significantly less weight than mainland coasts or major islands. Because they are small and scattered, it would be inequitable to treat them in the same way as a mainland coast. The effect of these relevant circumstances on the western lateral is that in order to achieve an equitable solution, the provisional equidistance line needs to be adjusted significantly towards the east. Mr. Chairman, at this stage it's important to recall that the 1972 agreement in place between Australia and Indonesia on the division of the seabed or continental shelf which you now see represented as a black line on the screen. That bilateral treaty, which, as we've seen, squeezed Timor-Leste and created the Timor Gap, cannot in any way affect Timor-Leste's sovereign rights. Though the exact location of the tripoint connecting the maritime boundaries of Australia, Indonesia, and Timor-Leste cannot be finalized without the presence of all three states, the result of applying the three-stage methodology to the maritime areas in the Timor Sea is illustrated in broad terms on the map now on the screen. This is the area of the Timor Sea claimed by Timor-Leste as subject to its exclusive sovereign rights under international law. I make the obvious point that the map only shows the claims in the Timor Sea, not to the north, where delimitation will be between Timor-Leste and Indonesia. Mr. Chairman, members of the Commission, I'll end my short statement with a few words about how we see your role in assisting the parties in solving their maritime dispute. We see your task as threefold. First, we hope that the Commission can assist the parties to reach an agreement on the delimitation of permanent maritime boundaries on the basis of international law, as referred to in Article 38 of the Statute of the International Court of Justice, in order to achieve an equitable solution, to refer once again to the language of UNCLOS. The Commission is to hear the parties and make proposals to assist the parties to reach an amicable settlement to the issues at hand. The primary aim is to achieve an agreement between Timor-Leste and Australia on delimitation. However, if the compulsory conciliation process does not conclude with an agreement resolving the dispute, the Commission is then to issue a reasoned report on all questions of fact and law relevant to the matter in dispute. The report is to include those recommendations the Commission finds appropriate for an amicable settlement of the dispute. And according to UNCLOS, the parties are then required to negotiate in good faith an agreement on the basis of the report. In addition to the issue of permanent maritime boundaries, a second task for the Commission is to assist Australia and Timor-Leste to agree on appropriate transitional arrangements in the disputed maritime areas to bring the parties from their current temporary arrangements to the full implementation of their newly agreed permanent maritime boundary. And finally, a third task for the Commission, and one related to the issue of transitional arrangements, concerns the post-CMATS arrangements. With the expected termination of CMATS, and with it the Timor Sea Treaty, the parties will benefit from the assistance of the Commission in finding the optimal way to come to a mutual position on dissolving the joint institutions and arrangements found in those provisional arrangements and moving on. Those CMATs can be terminated unilaterally, as previous speakers have already made clear. Mutually agreed steps to bring the provisional arrangements to an end are not only beneficial for the parties vis-à-vis each other, but are essential for the treatment of the private contractors operating under the legal regime of the soon-to-be-defunct JPDA. Mr. Chairman, members of the Commission, that concludes what I have to say, and I would ask that you call upon the agent of Timor-Leste, His Excellent Minister Aju Pereira, to conclude our presentation of this morning. I thank you.
Mr. Chairman, members of the Commission, I am honored to be here before you to bring the presentation of Timor-Leste to a close today. Initiating this conciliation process is a testimony to Timor-Leste's faith in an international legal order based on the rule of law. We ratified the United Nations Convention on the Law of the Sea in the belief that our maritime affairs, including the determination of our maritime boundaries, shall be governed by the rules of such a widely acceptable multilateral treaty. The preamble of the Law of the Sea Convention notes that its purpose is to contribute to the realization of a just and equitable international economic order, which takes into account the interests and needs of mankind as a whole, and in particular, the special interests and needs of the developing countries. As a nation modest in population and size, surrounded by two powerful neighbors, Timor-Leste takes great comfort in the basic principle of equality of states and the fairness of the international system. At the time of our independence in 2002, the United Nations Secretary General Kofi Annan said, "Never before has the world united with such firm resolve to help one small nation establish itself." And he also wisely observed that independence is just the very beginning of the long process of nation building. Today, we face an enormous challenge to provide our young people with the education, health care, and jobs they deserve. Our desire to bring stability and certainty to our maritime areas is very much a matter of practical necessity for the sustainable development of our young nation. Settling our permanent maritime boundaries in accordance with international law is the final stage in our struggle for sovereignty, a final mountain to climb in our journey to fulfill our right of self-determination. And this, Mr. Chairman, brings me to the second basic principle of the international legal order, one that is at the heart of Timor-Leste's position: that sovereign states shall settle their disputes peacefully. In the context of the law of the sea, this settlement is to result in a fair and equitable solution. Australia and Timor-Leste agreed to certain provisional arrangements in the Timor Sea Treaty and CMATS to operate in the period prior to agreement upon permanent maritime boundaries. It is not necessary for me now to go into the regrettable circumstances of the negotiation of CMATS Treaty, which have done so much harm to the trust and respect that should exist between Timor-Leste and Australia. This is not a time for revisiting past mistakes and misgivings. We are looking to the future. So there is one point that I should emphasize. The current provisional regime is near its end. CMATS is going. That is the policy of Timor-Leste. Even putting aside our views on the viability or validity of CMATS, if you give notice of termination on Article 12 of CMATS, CMATS and the Timor Sea Treaty cease to have effect 3 months later. It is our duty to ensure that proper transitional arrangements are in place before that happens. In the last months, the Minister of Natural Resources, Alfredo Pires, and I, with our Maritime Boundary Office and legal teams, have visited the oil companies with a stake in the Timor Sea. We have gone to see their senior executives personally, to explain the situation and to seek their views. We have done so in Perth, in Houston, and here in The Hague. Those visits have been very well received, and we are working on a post-termination plan to meet investors' requirements. the provisional resource sharing treaties between Timor-Leste and Australia that have not served their purpose will be removed. But Timor-Leste can only do this when the necessary preparatory work has been completed. And today, as we find ourselves here before you, we look to you, Mr. Chairman, members of the Commission, to bring us together in a spirit of mutual understanding and cooperation, in the words of the Law of the Sea Convention, with a view to assist us to amicably settle our maritime dispute. This is for the sake of the young and future generations of Australian and Timorese people. They must be freed from the burden of this lingering dispute and face the future together, sharing friendship, peace, and prosperity. Mr. Chairman, members of the Commission, this concludes the presentation of Timor-Leste today. I, along with the rest of the Timorese delegation, would like to thank you, the Registrar, and our Australian counterparts for the remarkable way in which the hearings are being conducted. Thank you.
Thank you, Honourable Minister, and thank you for the interventions from the government of East Timor. I think we are running ahead of schedule. I really like that. So now I will call a break and ask everybody to come back and be ready for Australia's opening statement at 11:15. Thank you. Welcome back from the break. I think we are doing very well. We're already 10 minutes ahead of schedule, so I'm very optimistic for the rest of the morning. Without further ado, I give the floor to Australia for their opening statement.
Thank you, Mr. Chairman and members of the Commission, and good morning, and distinguished representatives, of course, and Council for Timor-Leste. I would like in particular to acknowledge His Excellency Keirala Xanana Gusmao, well known to all of us, of course, Minister of Planning and Strategic Investment and Chief Negotiator for Maritime Boundaries. We've listened very carefully to the statement made by our Timor-Leste colleagues this morning. I'm honoured to present Australia's opening statement before the Commission. In the course of these remarks, I'll be quoting from a number of documents which I'll make available to the Commission and Timorese colleagues in accordance with the rules of procedure. We're mindful of the historic significance of this first ever Annex V conciliation proceeding constituted under the UN Convention on the Law of the Sea, and we're very fortunate to have a Commission of eminence and experience, and we're confident that the Commission will afford to the arguments of both parties the very careful consideration they deserve. These statements, of course, are being webcast live, and for those watching the proceedings, I think it's important that we speak plainly about the complex issues that are involved. Australia will reserve the detail of our argument for hearings in coming days, but at the outset I should underline that, as we know, we contest the competence of the Commission. Australia's view is that there is no proper basis on which Timor-Leste is entitled to bring this claim. Doing so violates treaty commitments, specifically the 2006 Treaty on Certain Maritime Arrangements in the Timor Sea. We all know, of course, it is CMATS, under which both countries have committed not to bring proceedings against each other on maritime boundaries. This objection, I should say, is not driven by politics or legal formalism, and certainly not by any failure to accord engagement with Timor-Leste the importance it warrants. It is motivated by a serious regard for principle. We don't think that Timor-Leste should use compulsory conciliation in an effort to oust the express treaty commitments it has made. Chairman, members of the Commission, Timor-Leste made a number of points this morning which we will address during the course of our statement and in coming days. But there is one point I would like to address up front from the start.
Timor-Leste talked about alleged Australian espionage. Timor-Leste has brought a separate arbitration claiming that CMATS is invalid on these grounds. Australia does not accept Timor-Leste's claims and is defending the validity of the CMATS treaty in those proceedings. It would be inappropriate to prejudge the outcome or to ask this Commission to treat Timor-Leste's allegations as fact. This is not the appropriate forum in which to raise these allegations. They're being tested in another forum where we are bound by strict rules of confidentiality, and I will respect those rules. Let me turn now to the actual dispute. Of course, the rest of what follows is without prejudice to our position on competence. It's obvious that the difference of view between Timor-Leste and Australia on where our boundary in the Timor Sea should lie is significant. The dispute is not new. It's existed since 2002. Timor-Leste and Australia tried to reach an agreement on maritime boundaries in 2003 and 2004, but we were unable to do so. Contrary to what has been said, that Australia pressured Timor-Leste to sign CMATS, it was in fact Timor-Leste itself that proposed that we defer maritime boundary delimitation in favour of what it described as a creative solution. Australia, in fact, initially wanted that creative solution to include delimitation of boundaries. Timor-Leste did not, and the agreement reached in 2006 in the CMATS Treaty includes a moratorium on boundary negotiations and a commitment not to take legal action on maritime boundaries. Timor-Leste was a strong supporter of CMATS. In a media interview in 2006, then Timorese Prime Minister Al-Khatiri said that Australia and Timor-Leste had, and I quote, found a creative way to benefit the two peoples, and that, quote, Timor benefits much more than Australia. His Excellency, of course, Xanana Gusmao, then the President of Timor-Leste, provided his presidential approval for ratification of the CMATS Treaty. But we're here today because Timor-Leste now wants a different deal. Australia's position is that the Commission should not disregard our treaties simply because one party has changed its mind. The three treaties governing the Timor Sea were negotiated over several years and represent what we genuinely believe to be reasonable agreed outcomes. Under the Timor Sea Treaty, Timor-Leste is entitled to 90% of the resources in our joint development zone, despite the area being claimed by both sides. Walking away from our treaty commitments would run counter to their purpose, which is to provide a stable framework for the joint development of resources. What Timor-Leste is proposing would damage the reputation of the parties, both parties, for providing a stable and secure investment environment in the Timor Sea. Moreover, at a time when the rules-based order globally is under serious challenge, it's vital that countries stand by their treaty commitments. Termination of CMATS, of course, is open to both parties, and Timor-Leste has said again this morning that CMATS will go. But Australia does not support its termination and certainly will not terminate it ourselves. We believe that CMATS and our other treaties in the Timor Sea are, as I've said, reasonable agreed outcomes. They are the best way to overcome a protracted boundary dispute. They're consistent with UNCLOS, they've delivered enormous benefit to both sides, and they can continue to do so. We acknowledge, obviously, that Timor-Leste disagrees, and we of course accept it is open to Timor-Leste to terminate CMATS, but we don't think that is the right path forward. Mr. Chairman, members of the Commission, Australia will set out for the Commission our views on the history of the dispute and the path forward. This statement will cover 4 areas. First, it will put the dispute in the context of the relationship we have with Timor-Leste. This is important because while our dispute on Timor Sea issues is significant and substantial, it does not reflect the totality of our very positive relationship, either past or present. Second, it will set out in detail the treaty regime which governs our relationship in the Timor Sea, The treaties are fully consistent with and indeed encouraged by international law. Third, it will seek to dispel some common misconceptions about boundaries in the Timor Sea and clarify what lies at the heart of the dispute. And fourth and finally, Australia will show why the best path forward is for Timor-Leste and Australia to work together as partners, respecting the existing treaties our two sovereign nations have concluded. Before I close this introduction, I want to address two misconceptions. The first is that conciliation could not be objectionable. Why shouldn't neighbours be able to enlist the assistance of a third party to help them resolve their differences? That may be true in many cases, but I should demur that it is not a mark of good neighbourliness to initiate a compulsory procedure in breach of your own treaty commitments to that neighbour. The second is that there may be a sense that the first Annex 5 proceedings should not stumble at a competence objection, but the systemic well-being of UNCLOS dispute settlement and of future Annex 5 proceedings requires that the Commission signals early and clearly that compulsory conciliation must conform to the requirements of the Convention. Frankly, it is not a procedure in which a state instituting proceedings can simply craft its own process. Mr. Chairman, members of the Commission, I'll turn now to the relationship between our two countries, and I do this to demonstrate three things. First, to give the Commission a broader context beyond this dispute and show that the sum total of our relationship is much greater than the issues that bring us here today, significant though they are. Second, that the extensive cooperation between our countries over many years shows that we have a strong foundation for a relationship based on mutual understanding and respect. Third, that although there are significant differences of opinion on Timor Sea issues, Timor-Leste is an especially important partner for Australia, and we are demonstrably committed to increasing our engagement. Mr. Chairman, members of the Commission, Australia and Timor-Leste are close neighbours, and we will always be important to each other. The ties between the Australian and the Timorese people are ingrained in our shared and at times tumultuous history. Many Timorese died while supporting Australian forces during World War II in then Portuguese Timor. This is an indelible part of our history, what Minister Xanana Gusmao described this morning as a legacy of solidarity, and we remember and honour the Timorese sacrifice. We don't pretend that this history has been free of difficulties. It's a fact that from December 1978 until the successful independence referendum in August 1999, Australia gave de jure recognition to Indonesian sovereignty over Timor-Leste. We're not seeking to avoid that fact. It's history. But it is equally true that during the 2.5 decades after 1975, Timor-Leste's resistance and struggle for independence were a matter of widespread public interest in Australia, certainly to my generation, and attracted the support of many Australians. It is also a fact that the contribution Australia made in the formative events of 1999 and afterwards in Timor-Leste deeply resonates in contemporary Australia. Australians are very conscious of the very high price that Timorese people have paid for this independence. Australia, of course, was instrumental in securing international support for the referendum process that led to independence. We provided significant financial and civilian police support to the referendum, and it was Australia which, despite the significant political obstacles, as has been mentioned this morning, built the international coalition and led the UN-mandated forces, INTERFET, which restored security and stability following the devastation unleashed on the country in the immediate lead-up to and in the aftermath of the referendum. Timor-Leste speakers this morning have commented graciously on the courage and solidarity of the Australian Defence personnel in INTERFET, over 5,500 personnel in what was Australia's largest peacekeeping deployment ever. I myself made a very small contribution as the diplomat in our Foreign Ministry, given the job of coordinating Australia's operational response to the crisis. In 2006, at the request of the Timor-Leste government, Australia again deployed peacekeepers to help restore order and security following an outbreak of violence. Australian peacekeepers remained in Timor-Leste under the auspices of the International Stabilisation Force under UN mandate until December 2012. We took a lead in helping to ensure that that mandate continued in terms that Timor-Leste itself wanted. Since independence, Timor-Leste has held 3 elections and made enviable progress in state building, economic and human development, and the development of its foreign relations. Its very active leadership, its admirable leadership of the so-called G7 plus group of some 20 countries emerging from conflict reflects the international respect for Timor-Leste's success as a post-conflict nation. Australia's relationship with Timor-Leste today is expressed through multiple levels of engagement. Significantly outside government, the Timorese and Australian communities make a strong contribution to community life in each of our countries. Hundreds of local government, school, church, university and community groups and individuals in both countries work together to help build stronger communities and a stronger partnership. Timor-Leste's history means that many Timorese and Australians have enduring personal bonds with each other. At the government-to-government level, Australia is committed to supporting Timor-Leste's security, stability and growing prosperity, its integration into the Indo-Pacific region and building our bilateral, regional and multilateral partnership. Our investment in Timor-Leste's success is demonstrated by our remaining Timor-Leste's largest security and development partner. Australia works closely with the Timorese government in implementing its strategic development plan under the stewardship of Minister Xanana Gusmao, focusing on improved livelihoods, enhancing human development, bringing basic services and building infrastructure and strengthening governance and institutions. We've contributed over $1.5 billion through our development cooperation program since 1999. Australia partners with Timor-Leste Defence Force and the Civilian Ministry of Defence through the Defence Cooperation Program, including by developing administrative capacity, strengthening engineering capabilities and providing English language training. This is Australia's second largest defence cooperation program with another country. Equally important is the contribution we make to capacity building for the Timorese police through the Timor-Leste Police Development Program. Again, this has been one of the largest policing programs ever undertaken by Australia internationally. So Australia's overriding objective is to work with Timor-Leste as a friend and partner to lock in the gains it has made since independence. We support Timor-Leste in its plans, its own plans, to diversify its economy, ensure fiscal sustainability, and to promote human development. The arrangements between Australia and Timor-Leste, the arrangements we've agreed in the Timor Sea, have played a decisive part in enabling Timor-Leste to accumulate a petroleum fund of approximately $16 billion US, which it uses to finance its state budget and which is almost 8 times its annual GDP. That fund has helped to underpin peace, stability, economic growth and made Timor-Leste a model of genuine success for post-conflict states. However, as the International Monetary Fund and others have noted, Timor-Leste's fiscal situation is under strain, particularly with declining oil prices. Timor-Leste is the second most oil-dependent country in the world, and the IMF has stated that its oil production may cease by 2023. We bring these issues to the Commission's attention only to illustrate some of our wider concerns about the likely consequences of abandoning the current treaties in the Timor Sea. In particular, casting the CMATS Treaty aside would, we think, create uncertainty and significant delay in the development of resources in the Timor Sea and interrupt the flow of revenue. I will stop here and not belabor these points. I make them only to show Timor-Leste's success as a nation, able to realise its own vision for the prosperity and security of its people, is genuinely a compelling interest that Australia shares. Mr Chairman, if the Commission agrees, Mr Justin Gleeson, Australia's Solicitor General, will continue our opening statement.
Thank you, Mr President.
Thank you, Mr President. It's an honour to appear before the Commission. As has been indicated, I will be dealing with the second and third of the 4 parts of Australia's presentation. The second part concerns the historical background to this dispute and seeks to establish that the existing treaties are reasonable, they are right, they are binding, and they reflect a legitimate position in international law. The third part of our presentation will look in some detail at the boundaries of the joint development area and also illustrate those boundaries currently established are a reasonable negotiated solution consistent with international law. They're the 2 substantive matters I'll cover. As will be apparent, the territory I seek to cover to some extent relates to matters raised this morning by Professor Vaughan Lowe and Sir Michael Wood. I will address some of the matters they have raised, but not all of them for obvious reasons. It's appropriate, however, at the outset to address 4 matters that you have heard this morning from those 2 speakers, and could I just deal with them in summary form? The first matter is that you have not heard a defence at law by Timor-Leste for why it brings these proceedings now in breach of Article 4 of CMATS, and we would submit in breach of UNCLOS. You have not heard such a defence from Professor Vaughan Lowe or Sir Michael Wood, and the consequence of that is, even if arguendo, which we would deny everything they said this morning were correct, none of it defeats the proposition that these proceedings are premature. The second matter I wish to refer to at the outset concerns something put forward to you by Sir Michael Wood at the tail end of his remarks. You may recall he said that Timor-Leste perceives there are 3 purposes that you have as a Commission. It will not have escaped you that the second and the third purposes he mentioned are not only outside the notification by Timor-Leste which commenced the proceedings, they are also on any view outside Article 298 of UNCLOS because they do not concern the matters in that article. So unfortunately, far from you hearing a legal defence for why Timor has brought these proceedings prematurely in breach of Article 4 of CMATS, you have in fact heard an attempt to broaden your jurisdiction beyond that which could be available on any view of the notification or Article 298, and Australia opposes that attempt by Timor-Leste to expand your competence even further beyond what on any view it could possibly be. The third of the 4 preliminary matters is you heard again from Sir Michael Wood twice a proposition, an assertion that Australia has issued acreage permits in aggravation of this dispute and in breach of the procedural rules you issued so recently. That allegation by Sir Michael is unfounded. It is rejected by Australia. Australia's conduct in this area, consistent with what has occurred for many years, is supported by Article 4, Sub-Article 2 of the CMATS Treaty and by the side letters exchanged between the 2 states. It was not something done just the other day under your nose. It was publicly announced in February of 2016 that these further permits would be issued. And the area of those permits is not that which Sir Michael Wood showed you on the map where he suggested it strayed into the JPDA. The permits are below and outside the southern boundary of the JPDA. We would ask you to place no reliance upon that assertion by Sir Michael Wood. The fourth preliminary matter is that, particularly in Professor Vaughan Lowe's, if I may say, comprehensive and helpful summary of the history, there were, however, a number of assertions of fact and of law which are either wrong or tendentious. It's not open to me within the current time frame to respond to each of those, and I won't do so, but I will simply make clear that we do not accept the entirety of what Professor Lowe put to you, just to illustrate three matters that he put to you which were wrong, three of a larger number. First of all, he submitted that Australia refused to negotiate maritime boundaries in the period leading up to CMATS. That is incorrect. Australia sought to negotiate maritime boundaries, and Timor-Leste said it was its preference to put that to one side and negotiate a resource sharing agreement. Secondly, he submitted that the 50-year period of CMATS was, to use his words, remarkably long and somehow abnormal, and somehow to be questioned or criticised or simply put to one side. The purposes for the 50-year period were agreed at the time by Timor-Leste and Australia as a period which was likely, not certain, but likely to allow for development of the Greater Sunrise Field for the benefit of both nations on a 50-50 sharing basis. There was nothing abnormal or unreasonable about the 50-year period. And the third matter I simply wanted to mention was he submitted that CMATS has outlived its usefulness. It has failed in its aim. As if you, a body solemnly charged with administering international law, could take a treaty and simply say on the submission of a party who no longer wished to be bound by it, oh, it's no longer useful, it's failed in its aim. That proposition is incorrect. CMATS has in fact been observed and followed, save for its breach in these proceedings, to the benefit of both parties, and that continues to be the case today. And Australia's position is that CMATS continues to provide a stable and appropriate framework by which development could occur in the future in the Greater Sunrise Field for the benefit of both nations. Could I then move to what we've identified as the part of our presentation which establishes that the treaties are reasonable and they are right and they should be respected. And in this sense, we will also offer you a slide presentation which to some extent will cover material you have seen this morning. It's not possible within the time frame to deal with the entirety of this material. But let me offer you at least an introduction to how Australia would see some of these important historical matters. The place that we would start for this morning's purposes is to identify that there are three key treaties relating to the Timor Sea. This is not to minimise that there have been other treaties, but the three absolutely central treaties are the Timor Sea Treaty of 2002, the Agreement for the Unitisation of Sunrise, 2003, and CMATS, 2006. The first point we would make about the three treaties is that they resulted from negotiations which were negotiations in which formidable senior Timorese and, in the early cases, United Nations officials pursued Timorese interests strongly at the same time as Australia pursued its interests strongly. It's important to note that Timor-Leste's first Prime Minister, Mari Alkatiri, and its first Foreign Minister, Jose Ramos Horta, were closely involved in the negotiation process, and that Timor-Leste, in relation to the first two treaties, had the support of senior United Nations officials, including former Ambassador Peter Galbraith, and external advisors providing significant technical advice and support. Australia would reject any assertion that the negotiation of the treaties was in any way one-sided, or, I think the word was uttered this morning, done under duress. Australia would reject that as a characterisation of the negotiation of any of these treaties. Could I turn then to the first of the three treaties, the Timor Sea Treaty, 2002, building upon, as Professor Lowe told us this morning, agreements reached with the transitional administration and Timorese representatives immediately leading up to independence. For present purposes, we would submit that there are 5 features of the Timor Sea Treaty that are important to note. The first feature is that the Timor Sea Treaty establishes the Joint Petroleum Development Area in the Timor Sea in an area of overlapping seabed and water column claims. You will see before you on slide 1 the JPDA. In terms of the boundaries of the JPDA, in summary, what is critical to note is that the northern boundary lies halfway down the Australian continental slope in the Timor Trough. The southern boundary follows what has been described today as the median line between Australia and Timor-Leste. And importantly, and this traverses some matters raised by Sir Michael Wood, the eastern and the western boundaries are the equidistant or median lines projected from between Timor-Leste and Indonesia. So the important difference in the historical arrangement which the states came to, and that which Sir Michael Wood says Timor-Leste would now seek to argue for, is that the eastern and western boundaries are equidistant median lines which respect both Timor-Leste and Indonesia. The second aspect of the TST is that it is a framework for the two states jointly to manage, control and exploit petroleum resources within the area for the benefit of both countries. The third aspect, which is important, is that under the 2002 treaty, 90% of the petroleum produced from the JPDA is allocated to Timor-Leste and only 10% to Australia. Fourthly, as Professor Lowe indicated this morning, the TST contemplated the parties would conclude a later agreement to manage resources that straddle the JPDA and the areas which were under Australia's exclusive jurisdiction, specifically Greater Sunrise. And if I could now show you figure 2, you will see there that the JPDA clearly captures the Bayu Undang reserve, which has been successfully exploited, and it captures about 20% of Greater Sunrise, with the balance of Greater Sunrise falling into Australia's exclusive jurisdiction. And that allocation, as Professor Lowe reminded you, of 20% to the JPDA and 80% to Australia was affected by the TST. And we might see on slide 3 a close-up indicating and confirming the divide of Greater Sunrise between the JPDA and the area of Australia's exclusive jurisdiction. The fifth and final aspect of the TST is that it applied for 30 years until 2033 or until final maritime boundaries were agreed, and it was without prejudice to the parties' maritime claims in the area. As I've indicated, the TST allocated the petroleum 90% to Timor-Leste and 10% to Australia. No doubt Australia pursued its interests in those negotiations, but it also recognised Australia's broader national interest in a stable, prosperous Timor state. The purpose of Timor-Leste receiving 90% of the petroleum included to provide for a more favourable position to Timor-Leste than under the previous Timor Gap Treaty, which has been criticised this morning by Professor Lowe, which allocated the revenue 50-50. And it's important to remember that at the time, that is June 2002, senior Timorese officials recognised the benefits of this treaty for Timor-Leste. And if I could remind you what Prime Minister Mari Alkatiri then said publicly, his words were these: "The treaty in the end, it's not just about the practical business of revenue sharing. The treaty establishes East Timor's relationship with its partners and the world. First, the treaty is a hallmark of East Timor's independence. Secondly, it embodies a commitment to an attractive and stable investment climate. And thirdly, it is an undertaking by East Timor to work together in partnership and friendship with Australia. It is well known that the negotiations between East Timor and Australia on the treaty were difficult. Negotiations always are, but the outcome was an enormous success and one which makes our relationship with Australia all the more solid." In the light of those remarks, which are accurate remarks, you will have some appreciation of Australia's approach to these treaties being treaties that are reasonable, treaties that are right, treaties that are binding, and treaties that provide a stable future development of these resources for the benefit of both nations. Could I then move to the second of the three treaties I mentioned, which is the agreement to unitise the Greater Sunrise gas fields? Professor Lowe told you that that was agreed in March 2003, which is correct. He said it did not come into force until 2007. We must observe that the reason for that was that Timor-Leste changed its mind and refused to ratify that treaty until 2007, by which time it had also achieved the benefits of the CMATS treaty. Can I then come to that third treaty, the CMATS treaty, which is obviously of central significance to these proceedings and to the competence objection made by Australia? We would submit to you that there are four key facts which put the negotiation of the CMATS treaty in its correct context. The first fact is that it was Timor-Leste which suggested deferral of maritime boundary limitation in favour of what it called the creative solution reflected in the CMATS treaty. The second key fact is that the moratorium in CMATS does not sit on its own. It is a key part of an overall package deal, as was well appreciated on both sides. The third fact is that at the time, Timor-Leste was well satisfied with the outcome of that treaty because of its substantial benefits for Timor-Leste. And the fourth fact is that since 2007, Timor-Leste has changed its mind about CMATS, and the operative cause of its change of mind is that it has failed to secure its preferred development option of a pipeline to its south coast. That is the operative cause for why the Greater Sunrise fields have not been developed. Could I just illustrate a few matters to bear out those four facts? The first fact was that Timor-Leste suggested the deferral of the maritime boundary delimitation in favour of a creative solution. That came about because in 2003, an exchange of letters between Prime Ministers of Australia and Timor-Leste agreed to commence delimitation of permanent maritime boundaries. The first round of talks in April 2004 revealed the parties had significantly different positions and it would be difficult to reach an agreement on a permanent boundary. As a result of those matters, Timor-Leste suggested the parties explore what was called by Timor-Leste a creative solution. It's important to observe that in September 2004, at the start of the second round of negotiations, Australia's position was that any creative solution would still need to deal with the delimitation of permanent maritime boundaries. That is, the very thing Timor-Leste says it wishes today, Australia was still seeking to deal with in September 2004. Timor-Leste said it did not wish to discuss permanent maritime boundaries. It was for that reason that the parties moved to discuss a creative solution which had three key elements. The first was long-term deferral of maritime claims. The second was the extension of the duration of the Timor Sea Treaty from 30 to 50 years. And the third, which is critical, was there would be a revenue adjustment in respect to Greater Sunrise, significantly in Timor-Leste's favour. There were then a further 3 rounds of negotiations seeking to bring those principles to the form of a treaty. On the 29th of April 2005, after a further negotiating round, the Timorese then Foreign Minister, José Ramos Horta, said the following in a media release. Timor-Leste, and I'm quoting José Ramos Horta, proposed a creative solution which may involve a resource-sharing arrangement in lieu of hastily attempting to resolve complex and sensitive issues involved in agreeing to a permanent maritime boundary. Mr. Ramos Horta went on to say he was confident that we are on the brink of securing an agreement to handle for a long period our competing claims in the Timor Sea and in turn unlock the enormous hydrocarbon potential of this region. Those were the negotiations which led to CMATS being signed on the 12th of January 2006. Next, can I indicate the extent to which the CMATS treaty was a package deal? The moratorium sat as part of a package in which Timor-Leste, and this was acknowledged this morning correctly, increased its share of revenue in the Greater Sunrise gas fields from 18% to 50%. The second element of the package was that Timor-Leste was given water column jurisdiction, such as for fishing activities, within the JPDA. And that's just but one illustration of why it's incorrect to say CMATS has outlived its usefulness. CMATS today is being taken advantage of by Timor-Leste to exercise water column jurisdiction to grant fishing rights and licences in the JPDA. And the third element of the package, as I've mentioned, was the 50-year moratorium. Now, let me say a little bit more about the moratorium. Obviously, it's central to CMATS. Why was there a 50-year moratorium on maritime boundary claims, on legal proceedings and further negotiations? The reason was to provide certainty to investors about the legal and regulatory regime so that they could make their decisions expeditiously and allow the resource to be developed so revenues could also flow to the two states. As I indicated a little earlier, the 50-year period was designed and appreciated by both states as being a period likely, not certain, but likely to cover the utilisation of Greater Sunrise to provide stability over the entire lifespan of the development. If I could indicate to you again an appreciation of this at the time by Mr. Ramos Horta as Foreign Minister, he said this publicly in October 2005, and I quote, "It is the view of the two sides that we should observe a moratorium on maritime boundary delimitation for a period coinciding more or less with the life of Greater Sunrise, while at the same time we would have a 50% share of the resources." So the deal, which was rational, which was reasonable, which was right and which was binding, was Timor-Leste would increase its share of Greater Sunrise from 18% to 50%. It would obtain water column jurisdiction over the JPDA, and there would be a 50-year moratorium for the specific purpose of allowing exploitation of these resources so that benefits could flow to both countries. The next fact I mentioned was that at the time, that is 2006-2007, Timor-Leste was well satisfied with CMATS, recognising its substantial benefits. Prime Minister Al-Khatiri said the following in a press release. He described CMATS as a win-win outcome which takes account of the essential interests of both states. As Professor Lowe recognised, within the democratic system of Timor-Leste, there were two further steps to CMATs coming into legal force. The first, it had to be considered by the Timorese Parliament. It was considered, achieved an overwhelming majority, and on the 20th of February 2007, the National Parliament passed the ratification resolution. On the 21st of February 2007, His Excellency Xanana Gusmão, then President, provided, as we've heard, his presidential approval for ratification of the treaty. They are the reasons why, within the democratic system of Timor-Leste, the CMATS Treaty came into law. And it was also at that time, as I've mentioned, that the IUA was ratified. Let me come to the final of the four facts I've submitted to you concerning CMATS, and that is that it was Timor-Leste which has subsequently changed its mind about this treaty after failing to secure its preferred development option of a pipeline to its south coast. Before doing that, I wish to confirm again that both parties have positively implemented various obligations under CMATS, including Timor-Leste exercising its right to exploit fishery resources inside the JPDA by issuing fishing licences. What is it that occurred since 2007? The critical fact is that since 2007, Timor-Leste began to submit that the only development option it would be prepared to consider was a pipeline running from Greater Sunrise to the south coast of Timor-Leste, with downstream processing then being able to occur on that south coast. How does that insistence by Timor-Leste sit with the legal regime established by the treaties? Under the treaties, Australia and Timor-Leste agreed sensibly that it would not be for either or both government to dictate how Greater Sunrise would be developed. Rather, it would be for the contractors to bring forward a development plan which was commercially sensible and feasible, and the parties' regulatory authorities, that is the state's regulatory authorities, would assess the development plan of the commercial investor by this criteria. The relevant criteria was whether the plan provided the best commercial advantage consistent with good oil field practice. It's important to note that Australia has remained neutral on the question of where or how the pipeline should run. This is a commercial and technical issue. It is not for Australia, nor for Timor-Leste, to put forward a development option. It is not for Australia to oppose the concept of a Greater Sunrise pipeline to Timor-Leste. Australia's approach, consistent with its treaty obligation, is that it will participate in the joint assessment of the plan put forward, as I've said, to consider whether it provides for the best commercial advantage consistent with good oil field practice. It's next important to note that by about 2010, the Greater Sunrise joint venture, having conducted their assessment, came to two conclusions. And you have not heard these conclusions this morning, but they're important to understanding this dispute. The first conclusion was that laying a pipeline from Greater Sunrise to the south coast of Timor-Leste would be technically and environmentally risky, given that the pipeline would be laid across a seismically active trough approaching 3,000 metres in depth. The second conclusion was that a pipeline to Timor-Leste would be commercially inferior to the two alternatives, the first being a floating LNG platform and the second being a pipeline to Darwin. That is the material which has been put forward by the commercial venturer to the two states for them to consider and approve in order to allow this field to develop. However, the following has been Timor-Leste's response. Firstly, in mid-2009, it said publicly, any plan by the venturers to use floating LNG or to construct a pipeline to Darwin would be rejected. In April 2010, the joint venturer announced it had selected floating LNG as its preferred development concept, yet this was immediately dismissed by Timor-Leste. In May 2010, the joint venturers delivered their formal development proposal for floating LNG to the Timor-Leste petroleum regulator, who refused to accept it. In July 2011, when Timor-Leste released its strategic plan, it indicated that the only option was still to be a pipeline to Timor-Leste. What those facts show, which I've gone into in a little detail, is that the lack of development in Greater Sunrise is not because of any deficiency in the Timor Sea Treaty framework. It is rather because Timor-Leste is not satisfied with the proposal which has been put forward by the commercial venturers. And that provides the true context in which, around 2011, Timor-Leste first began to indicate publicly that it was looking beyond the existing treaty framework. It was considering the termination of CMATs and, to use its words, the possible breaking up of CMATs is what it said publicly. My conclusion of this part of the presentation is that the operative cause for why Greater Sunrise has not been developed is simply that Timor-Leste insists upon an option which the commercial venturers do not wish to pursue. And Australia's approach is that it is not a sound reason to discard a treaty framework that took 5 years to negotiate and which the parties have previously acknowledged meets their interests, under which substantial work towards development has been done, simply because one state makes a preference for a commercial matter such as a pipeline. Mr. President, members of the Commission, that is what I wish to say on the second part of Australia's four-part presentation. I trust you now have a good idea of the approach Australia is taking to the importance of these treaties and to the current circumstances that we find ourselves in. Could I then move to the third part of our presentation, which to some extent will deal with some of the matters raised by Sir Michael Wood, in the sense that I will also put some submissions to you concerning the boundaries of the joint development area. The difference in our approach, however, will be that I will commence from the history and the facts and seek to show how it is that the current boundaries have come to be developed and to show that they are a reasonable negotiated solution consistent with international law. He has approached the matter from the opposite end. This is what Timor-Leste would like to argue for, assuming one were in a full maritime boundary negotiation. The one other matter by way of preface before I give you this part of our presentation is that Sir Michael put to you in a fairly free-flowing fashion that natural prolongation, to use his words, is out of date, and the modern regime of the law of the sea treats every state as entitled to a 200 nautical mile continental shelf, and to use his words, natural breaks and geomorphology are now irrelevant to maritime boundary delimitations. The place for arguing that matter is elsewhere, but could I simply affirm Australia rejects that summary of this area of the law, and one only need to read Article 74 of UNCLOS to see that natural prolongation remains one of the two ways in which a continental shelf can be conceived of and brought into a maritime boundary delimitation. And I refer you to Article 76, subarticles 1 and also subarticles 2 and 3 for that fact. So with that in mind, could I now turn to look a little more closely at how the boundaries have in fact been built up. I'll ask first for you to be shown Figure 4. In Figure 4, you will see the extent of the prolongation of Australia's landmass, and you will see from the chart or the code that the colouring indicates that Australia's landmass naturally extends a significant distance into the Timor Sea at depths which are relatively shallow, 50, 100, 150, perhaps approaching 200 metres. Then what you see is the Timor Trough. You see the slope of Australia's continental shelf. You then see the very deep Timor Trough with depths down to 3,500 metres, an average depth of about 2,800 metres. And then you see a very sharp rise up to the landmass of Timor-Leste. What that demonstrates is that the physical continental shelves of Australia to the south and Timor-Leste and Indonesia to the north are entirely separate. They are separated by the Timor Trough, and the Timor Trough is indeed deeper than the highest point on the landmass of either Timor-Leste or the Australian continent. Now, these characteristics, which Sir Michael says you simply ignore, are significant factual characteristics, geologically, geomorphologically and ecologically, and they create a distinction between Australia and its northern neighbours, Indonesia and Timor-Leste. And they're matters which Australia would, in an appropriate forum, submit remain relevant in a maritime boundary delimitation. I'll next ask for you to be shown Figure 5, which, similar to what Professor Lowe showed you, indicates the 1972 seabed boundary line established under the treaty between Australia and Indonesia. What Figure 5 adds, which you have not yet been shown, is that it maps the 1972 boundary onto the prolongation, the natural prolongation of Australia's land mass. And it explains the rationale for the 1972 line. Next, as you have been told, the 1972 agreement left a gap in the area between Australia and Indonesia known as the Timor Gap. Australia submits that that was done in proper recognition of the fact that Portugal at that time would be entitled to claim interests in the Timor Sea. Now, the precise position of the gap was based on a line of equidistance projected from the coast of Indonesia and the coast of then Portuguese Timor. As you've heard, between 1979 and 1989, Australia and Indonesia entered further negotiations with a view to closing the Timor Gap. While a permanent maritime boundary was not established, in 1989 the Timor Gap Treaty was entered. On slide 6 you'll see, and you saw something a little similar this morning, the 1989 treaty mapped onto the 1972 boundary, and under the zone of cooperation which was established, there was to be an equal sharing of benefits in the area identified as Zone A. Conversely, Zones C and Zone B would be dealt with solely for the benefit of the closest state. What's important is that Zone A covers substantially the same area as the JPDA then established under the following treaty. You've also heard that in 1997 Australia and Indonesia signed the Perth Agreement, which has not yet come into force. The reason to go through this history and this fact is to show that the current boundaries for the JPDA have two important features. Firstly, they reflect the significant natural prolongation of Australia's land territory, as well as reflecting claims based on the median line. And secondly, and in relation to the lateral boundaries, they have been established in a way that it does not infringe upon claims of Portugal or later Timor-Leste. Could I next turn to Figure 7? There we have again the JPDA. And you've already heard a little as to the northern and the southern boundaries of the JPDA. What I would next like to do is to demonstrate to you through slide 8 the manner in which the lateral boundaries of the JPDA were established as median lines from the area. Now, what you'll see on Figure 8 will be the western lateral being established. And it's a median line, and it is also an equidistant line, giving weight and effect to various points in the physical geography of the area. Next, you'll see the manner in which the eastern lateral is built up. And I might just pause there with the eastern lateral to observe that it is being built up, giving weight both to the landmass of Timor-Leste and to islands in the Indonesian archipelago. I'll then ask for you to be shown Figure 9. What we see from Figure 9 is that when Portugal granted petroleum concessions, it also used the western and the eastern lateral built up in the manner I've identified. What you see then on Figure 10 is the western and the eastern lateral together with the Portuguese concessions in red. And next, under Figure 11, you'll see how those laterals, properly established as median equidistant lines, matched the 1972 treaty. And further on, Figure 12, you'll then see how they matched the Zone of Cooperation of the 1989 Timor Gap Treaty. And then under Figure 13, you'll see they match the JPDA. So pausing just at Figure 13, through the principles that I have identified, one can see the consistent basis upon which the laterals have been established under each of the arrangements up until the present. Mr. Chairman, members of the Commission, it is often claimed and repeated in various ways this morning that Timor-Leste's claim is no more and no less than a claim to the median line, which will put the whole of Greater Sunrise in Timor-Leste's jurisdiction. Let me show you that is not the case. There you have before you the western and eastern laterals on figure 15, which have been built up in the manner I have earlier indicated. You have on the southern boundary of the JPDA the Australia-Timor coastal median. Let us now look at the location of Greater Sunrise. And what one can then see is that use of the median lines in the manner I have developed them today, consistent with history, would be the reason why 80% of Greater Sunrise falls outside the median line. You've heard this morning a presentation from Sir Michael of the manner in which Timor-Leste would seek to have the laterals drawn. It is not appropriate for Australia in this commission at this time to be dealing with those matters in detail, because of course that goes to the very heart of the matters that would be discussed if our competence objection were to fail. So I do not wish, and I don't think it's appropriate and perhaps desired by you, for there to be any substantive response to that at the moment, and we certainly don't propose to show you a slide presentation contradicting what Sir Michael has put. They're matters which are not for the present time. I do simply need to observe a few general points to put in context what's been put to you. Firstly, and this was probably acknowledged near the end of Sir Michael's presentation, Timor-Leste is proposing new laterals, essentially either ignoring or leaving for another forum and day the claims of Indonesia. They're drawn on a basis of a contention between Timor-Leste and Australia, ignoring the claims of Indonesia. The effects of that are that were any such laterals to be pursued, they would have the consequence of either requiring Indonesia to surrender maritime sovereignty it currently has, or Australia, or both. Mr. President, members of the Commission, at that stage I've concluded the matters I wish to put on this part of Australia's presentation. I've given you our historical perspective on how the boundary lines have come to be drawn as they are, and at this stage I'd ask, if convenient, to hand over to Mr. Quinlan to conclude our presentation.
Mr. Chairman, members of the Commission, thank you. In our concluding comments, I'd now like to put forward 4 reasons why Australia believes that it's in the best interests of both parties to support the current treaties. First, the treaties represent, as I hope we've demonstrated, a reasonable agreed outcome. In fact, the Timor Sea Treaty and the subsequent treaties really are a model example of how 2 states can work together for mutual benefit, despite different views on how to finalise boundaries. The treaty framework has provided the certainty and stability to enable the early exploitation of resources, so revenue could start flowing immediately to Timor-Leste. The stable revenue provided by the 2002 Timor Sea Treaty was particularly important for supporting Timor-Leste's recovery from conflict and economic development in the first years of its independence. In addition to providing a stable revenue stream to Timor-Leste, the Timor Sea treaties have enabled that country to benefit from Australia's considerable expertise in offshore oil field regulation, which has assisted to build its own capacity in oil and gas regulation. The stability and experience brought by Australia's involvement in regulation of the joint development area has also been instrumental, we believe, in fostering investment. One of Timor-Leste's arguments for dispensing with the current treaty framework is that it claims Australia has exploited Timor-Leste's vulnerability as a developing state. I hope we've demonstrated this is simply not true, nor is that claim compatible with the undeniable benefits that have flowed to Timor-Leste since the Timor Sea treaties were agreed. Timor-Leste proposed many of the key aspects of these arrangements itself, celebrated them at the time as major achievements, and has benefited significantly from them. Second, the treaties do exactly what the Convention on the Law of the Sea encourages us to do, to enter into cooperative, provisional arrangements pending final delimitation. Far from being an obstacle to sovereignty, as Timor-Leste has sometimes suggested, when Australia and Timor-Leste negotiated and agreed to the treaties, the two countries were in fact exercising their rights as sovereign nations as well as achieving the objectives of UNCLOS. The preamble to UNCLOS recognises one of the key purposes of the Convention is, quote, to promote the peaceful uses of the seas and oceans, the equitable and efficient utilisation of their resources. The Convention in Articles 74 and 83 obliges states to make, again I quote, every effort to enter into provisional arrangements of a practical nature, pending delimitation. In this way, maritime delimitation should not necessarily be seen as an end in itself. As noted by the inaugural President of the International Tribunal for Law of the Sea, Thomas Mensah, and I quote, joint development zones may be seen as one way by which states can implement the letter and spirit of the provisions of the Convention on the Law of the Sea relating to delimitation of maritime boundaries. Following a conciliation between Iceland and Norway regarding the island of Jan Mayen, the chairman of the Commission appointed to hear this matter wrote about the benefits of joint development zones, stating, and again I quote, the merit of a joint development zone, as opposed to a division of territory, lies in minimising the potential for conflict, often by eliminating competition over the ownership of resources. It converts the otherwise intractable issue of ownership into a question of distribution and of quantity. How much can each state be assured of obtaining from the disputed area? This, of course, is what Australia and Timor-Leste have done. It's also what a number of states in our region and elsewhere have chosen to do. Malaysia concluded arrangements with Thailand for the joint exploration and exploitation over a 50-year period of the non-living natural resources of a defined seabed area in which the two countries have unresolved overlapping claims to the continental shelf. Provisional arrangements were likewise concluded between Malaysia and Vietnam to create a joint development zone lasting up to 40 years. Similar arrangements have been concluded by Japan and the Republic of Korea, which have agreed to jointly develop a zone in the East China Sea for up to 50 years. These periods have not seemed abnormal or remarkable. Of course, not all states are able to agree on joint development when unable to resolve their maritime claims, but by agreeing to put aside our differences and to cooperate through arrangements for joint development, Timor-Leste and Australia avoided a protracted standoff of the type so often seen elsewhere. Third, we must honour our commitments and uphold our obligations. Despite years of negotiations, extensive give and take on both sides, and numerous statements by both countries that the agreements reached serve the interests of each party, Timor-Leste is in fact seeking to avoid giving effect to a commitment it not only voluntarily entered into, but in fact proposed. What Timor-Leste is now proposing would undermine the reputation of the parties for providing a stable and secure investment environment in the Timor Sea. Companies which invest billions in developing resources are entitled to expect a level of certainty that countries will abide by the legal regime they have established. Significant reputational harm would be caused by disregarding the treaties, and broader principles of international relations and international law are also at stake here. Fourth, reopening negotiations would add to uncertainty and further delay the flow of revenues from Greater Sunrise. We're aware from the IMF and other reports that oil production in the joint development area could stop as early as 2023, and there are no new resources scheduled to come online. The Timor Sea treaties provide us the building blocks for exploitation of Greater Sunrise, unitisation, revenue share, governance. Casting aside the Timor Sea treaties would put us back to square one. Mr. Chairman, members of the Commission, in concluding, I hope we have shown that Australia has always been willing to work with Timor-Leste to jointly develop Timor Sea resources. The current treaty arrangements are a proven foundation for investment. They provide a solid framework for the successful development of Greater Sunrise. The argument that Australia is holding back Timor-Leste's development is not true. The reality is that Timor-Leste's change of heart in relation to the Timor Sea treaties has created uncertainty, raised sovereign risk, undermined investor confidence, and considerably delayed Greater Sunrise's development. This will only be exacerbated by reopening the treaties. For the reasons we've outlined, we think we should instead devote our time to jointly developing the Timor Sea's resources under our existing joint development framework, as both sides originally intended. This would ensure revenue from Greater Sunrise would start flowing as soon as possible. Mr. Chairman, members of the Commission, as I noted in opening today, our remarks on the issue of maritime boundaries are, of course, without prejudice to the objections we've raised to these proceedings and to the competence of the Commission. And these objections will be developed over the course of this afternoon and the coming days. On the wider issues, as I said also at the beginning today, Australia does not pretend that the course of our relationship with Timor-Leste has been free of difficult issues. We are seeking neither to avoid history nor downplay the significance of Timor-Leste's story of resistance, independence and development, which we deeply respect. The bottom line is that we are committed to a strong and empathetic relationship with Timor-Leste. We remain Timor-Leste's largest and closest security and development partner. We have a vital interest in Timor-Leste's success as a nation able to achieve prosperity and security for its own people. And Australia is, in fact, confident that we can overcome our differences on the Timor Sea in a way that is equitable and reasonable, and that respects the obligations we owe each other as neighbours, close neighbours, and sovereign states. Thank you.
Thank you very much. I thank the delegation of Australia for its opening session. This is almost brings us to the end of the opening session. Before we close, I note and thank both delegations for very comprehensive and enlightening interventions. It has been very useful for me and my colleagues to understand where each delegation comes from and how you see these difficult issues that you have been discussing this morning. I also note that Sir Michael Wood presented East Timor's expectation of this commission and put it out in three different elements, and that this is disputed by the Australian delegation. I look forward to continuing that part of the discussion after our lunch break. I think that maybe should be dealt with in a closed session, so I will call 1.5 hours lunch break. We have now 1.5 an hour, so we're doing very well. Hope to see you all back here at 2 o'clock for our continued deliberations, and this closes our opening session, and the public session is almost also closed by now. Thank you very much.